How y'all doing out there in America? We're going to make America great again one day. It's coming soon. God is great. The Lord is true. I'm not sure if y'all remember, or if y'all, my subscribers or what have you. I appreciate every one of y'all. I appreciate everybody. God is great. My fight is strong. I'm still fighting in federal court. Well, they just did a final judgment in regards to my case. They dismissed the whole case. Nobody did no wrong. The officers didn't do nothing wrong. I guess I didn't do nothing wrong. But apparently the judge decided upon their statutes of laws that I broke the laws, and they had probable cause to arrest me. I was arrested for resisting arrest. And so on and so forth. And I'm not sure if y'all can hear me or not. But I'm hoping somebody can hear me, because I think I just did a whole 40-something minute thing where can anybody in there in the chat, can y'all tell me if y'all can hear me or not? Let me see. I don't know what else to do. But anyway, I'm looking to try to figure out. Give me a second. I don't know if y'all can hear me or not. But again, my case pertaining to me being arrested unlawfully. They ripped me out of my car, broke my arm touched backwards. It snapped my elbow, and so forth. So I'm just trying to figure these judges and lawyers and stuff. They're all in the same part of the corruption. But pursuant to an order adopting the United States Magistrate Judge Report and recommendations on the same date as is ordered, the judgment is entered in favor of defendant Anthony Grantham against plaintiff Edward Lee Gonzalez. This is an order, a final judgment, full and final judgment as to all claims and parties of the instant action. All relief not specifically granted herein is denied. The court is directed to close this case. It is so ordered. And so on forth. So they refused to hear my case. They said that the cop that arrested me didn't use excessive force, and my case is mainly an excessive force case. What consists of excessive force in regards to the law? If you understand the law, whenever you have an excessive force case, what brought to that point of being excessive? So all of a sudden, they claimed that they didn't do excessive force. Well, I mean, but I had submitted a case, a dispute between the judge's report on the 8th, and I submitted the documents, which they have them already, to the courts. I submitted all this to them again, and they said it in that documentation there that they wasn't looking at the evidence that I submitted to the court with this docket. But this docket tells everything, tells what happened. It tells pretty much 241, 242 United States Code of Color of Law. deprivation of rights of citizens. If two or more persons conspire to injure, oppress, threaten, or intimidate any persons in any state, territory, commonwealth, possessions of district, or in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same. So that being said, that was the two women who stole the keys from me and my wife. And then it says, in the appearance of an act being performed based upon legal right or enforcement of statute, when in reality no such right exists. An outstanding example is found in a Civil Rights Act, which penalizes law enforcement officers for violating civil rights by making arrest under color of law of peaceful protesters or disrupted voter registrations. It could apply to a phony traffic arrest in order to raise revenue from fines or extort payoffs to forget the tickets. So it's a crime for one or more persons to use power to him or her by a government agencies, local or state or federal, to willfully deprive or conspire to deprive another person of any right protected by the Constitution or the laws of the United States. I mean, that's pretty much, it says it all in a mouthful. So if you look at my video and you see the body camera footage of what they did to me, they broke every law that they had that they made. I mean, I told the cop pretty much, don't reach your hand in my car, and I locked my door. What do? You reached my car and locked the door. I mean, don't open my door, don't take me out. I mean, each law I told them, but they said they could, and they did it. They did that. So I'm not mad. You did what you did, but you got to do the same thing I got to do, is pay for your crime. But this is the instant report from the arresting officer, and it says here, drugs in. It says alcohol in. So, and it says two separate charges. It says resisting arrest, and it says disorderly conduct. I only had one charge. It was resisting arrest, or one alleged charge. Okay. And you see it there. He says alcohol in and drugs in. So he didn't think I was on drugs and think I was on drinking, drinking. So this officer says I wasn't drinking and wasn't on drugs. And then they arrested me for resisting arrest. So whenever you look at this report that this officer wrote, this is his stuff, not mine. Arrest report. Resist arrest. What does that say? It says the N, right? Arrested before N. So I wasn't resisting, and I wasn't drinking, and I wasn't on drugs, but I was arrested for resisting arrest. I don't know how that makes sense, but that's what they did. So resisting arrest is a secondary charge. It's right there, resist arrest. But it's a secondary charge where if you was intoxicated or whatever, you get charged for public intoxication. They could charge for resisting arrest because you didn't want to be arrested. I mean, they could state numerous things. But anyway, but the woman inside the facility lied and said this and said that, and her partner conspired. They lied. Everybody lied. They want to pursue charges. I mean, it's just ridiculous, all their statements. The detective on the 11th, I walked, July 11th of 2022, I walked to the police department and to get my incident report to see what I was being charged for and what they was trying to charge me for, and they had resisting arrest and disorderly conduct, and I didn't like the disorderly conduct. But anyway, the detective ordered a probable cause affidavit for arrest for resisting arrest. Well, I mean, I only I don't know where he went to school at, but you don't do that. I mean, you got to have a charge other than resisting. So he wanted my statement on 11th. I'm sorry. They didn't want my statement on 11th. On the 12th, they called me and said they refused the charge. But he misinterpreted it. They temporarily rejected it. That's an intake submission form. Well, then because they wanted my statement, and they called me on the 12th and or the 13th and wanted to get my statement of July of 2022, and I told them no, let's take it to trial. And then so I guess they submitted a DVD that was submitted by a detective, and they refused it on the 25th of July. So it was refused by the district attorney on the 25th of July. So I wasn't sure if I can go to the place who caused all this havoc. So I had to go to the police department to see if they had a trespass warrant. So I did an open records request for the trespass warrant, and I had to go actually up there to get my trespass, and it wasn't until 9:20 is when they finally trespassed me from the place where they said that in case they wanted to criminal trespass me. Well, because they exonerated me because of that DVD, I requested it through. I submitted a subpoena for that DVD. Well, now they gave me a letter back from the attorneys of the detective that I submitted it to, and they said that they're not in possession of the DVD. So I guess the DVD just disappeared. But there's pretty much what I'm fighting right now. That's my case, whole case in a nutshell. But right now the court is so corrupt. They're not allowing me to have trial and what have you because they're corrupt. But I just want to get on here and just kind of touch base with y'all and tell y'all what I'm going through and what I've been through. I've been filing motions pretty regularly. This is my filings. So if I would have done a tenth of what they done, I'd already been under the jail, and what have you. But I just so they refused my case I got it on the 1st of November, and I had 14 days to file 14 days to file a notice of appeal for our new trial. I never had a trial. I never got to that point. They refused my trial, and they're saying nobody did nothing wrong. But so that wasn't in the works for me. So then I had 28 days to file a motion for reconsider. So that's when I went ahead and did. I filed a motion for reconsider, and within it, I filed it yesterday. Pretty much with all that paperwork with their law and their stuff. But according to the rule of law, I have to have a trial. Somebody was guilty of something. I didn't break my own arm, but anyway, it's been a rough road. I don't know if I'm going to peel it from here, but we're going to see. God's been with me 1,000%. It's just been a rough road. There's a lot to tell right here. I mean, it's just one big corruption. I just hope nobody has to go through what I go through. That they want you to give up. If you don't understand the terminology of their sayings, like this is their definitions of their everything that you're going to be charged with, not charged with, but what their definition of. So like if you're gonna Consent. Effective consent includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud, given by a person or the actor knows is not legally authorized to act for the owner. So that's consent. So that means that the two women didn't have consent to take property from me and my wife. Whereas the owner means a person who has the title to the property, possession of the property, whether lawful or not, or greater right to possession of the property than the actor, or as the holder in due course of a negotiable instrument. That means that the people inside the facility cannot take any property from me and my wife without the person's, the owner's permission. So, with that being said, they all violate the law, but because the government is so corrupt and what have you, it's just been a fight. But anyway, I just want to get on here and just tell y'all what's going on. I'm still at it, still going to try. If I got to go to the Supreme Court, that's where I'm going to go. But it's just ridiculous that a person has to fight this hard to prove his innocence and the government's corruption to the government, and the government just turns a blind eye to it. But whereas this Chevron deference right here, it states that if because of the law has changed June 28th of 2024, the because of that Chevron deference, they have to actually hear my case for the fact that because it's a constitutional controversy. Um, but anyway, uh, it says rather than adjudicate it from the power of the politics. To ensure a fair hearing without respect to persons, as the Federal Judicial Oath demands, 28 U.S.C. 453, Chevron deference requires courts to place the finger on the scales of justice in favor of the most powerful of litigants, the federal government. Along the way, Chevron deference guarantees systematic bias in favor to whichever political party currently holds the levers of execution power. The federal, all of this is to serve to ensure the same thing: a fair trial and a fair tribunal, which in impartial judges, not those currently wielding power in the political branches, would say what the law is cases coming to court. For judges have neither force nor will, but merely judgment and an obligation to exercise the judgment independently. The Federalists, no matter how disagreeable that duty may be, the court has said a judge is not at liberty to surrender or to waive it. The duty of an independent judgment is perhaps the defining characteristic of an Article III judges. The court must identify the specific constitutional right alleged infringed by the constitutional right allegedly infringed by the challenged application of force, and then the judge declaimed by reference in specific constitutional standard which governs that right. Claims that law enforcement officials have used excessive force in the course of an arrest, investigating stop, or other seizures of a free citizens of the or most properly characterized I can't say the word characterized as invoking the protection of the Fourth Amendment, which guarantees the citizens the right to be secured in their persons against unreasonable searches and must be judged by reasonable standard. Chevron deference is inconsistent with the directions Congress gave us in the APA, as represents a grave anomaly when viewed against the sweeping historical judicial practice. The decision undermines the core rule of law values, ranging from the promise of fair notice to promise of a fair hearing. The Fourth Amendment reasonableness inquiry is whether the officer's actions were objectively reasonable in the light of the facts and circumstances confronting them, without regard to the underlying intent, motivation, the reasonableness of the particular use of force must be judged from a perspective of a reasonableness officer on the scene. And the calculus must embody an allowance for the fact that police officers are often forced to make a split-second decision about the amount of force necessary in a particular situation, to balance the necessity of the use of force used against the arrestee's constitutional rights. Evaluate several factors, including the severity of the crime at issue, whether the suspect poses an immediate threat to safety or to others, of officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Graham factors 490 U.S. And stating that in determining if the force was reasonable, the court may examine the need for the application of force, the relationship between the need and the amount of force used, and the extent of the injury inflicted. As the court also recently explained in Lee, Graham dictates unanimously that the force used by police officers in carrying out an arrest must be reasonably proportionate to the need of that force. For that force, which is measured by the severity of the crime, the danger to the officer, and the risk of flight. The power of the executing officer over a person's liberty ends with a lawful arrest. If he never has a discretionary power to detain the person without judiciary authority, the power to arrest does not confer upon the arresting officer the power to detain a prisoner for other purposes, trespasses ab intinui, due process of law. The Administrative Procedures Act of 1946, APA, directs a reviewing court to decide all relevant questions of law and interpret relevant constitutional statutory provisions. 5 U.S.C. 706. When applying Chevron deference, reviewing courts do not interpret all relevant statutes provisions and decides all relevant questions of law. Instead, judges abdicate a large measure of that responsibility in favor of the agency's officials. Their interpretations of ambiguous laws control even those interpretations are at odds and with the fairest reading of law an independent reviewing court can muster. An agency, too, may change their minds about law's meaning at any time, even when the Congress has not amended or relevant statute language in any way. National Cable and Telecommunications Associations. Not only was the Constitution adopted against this backdrop of these understandings, and in light of that alone, they may provide evidence of what the framers meant when they spoke of judicial power. Many other more specific provisions in the Constitutions reflects much of the same distinction between lawmaking and law finding fractions the common law did. The Constitution provides that its terms may be amended only through the certain prescribed democratic processes. Article 5. It vests the power to enact federal legislation exclusively in the people's elected representatives in Congress. Meanwhile, the Constitution describes the judicial power as the power to resolve cases and controversies, as well as delegates that authority to life-tenured judges, an assignment that would have made little sense if judges would usurp lawmaking powers vested in periodically elected representatives. But one that makes perfect sense is if what is sought is a neutral party to interpret and apply the law without fear or favor in a dispute between others. In opinion, Judge Connor said the imprisonment in jail of a citizen without a warrant, without opportunity for a hearing or to give bail is a serious matter, and determine whether or not an officer's failure to take an arrested man before administrate immediately after his arrest was an unnecessary delay. The Supreme Court of Texas stated the accused has a right to be present without delay, but the question of what is a delay must be determined by all the facts and circumstances. Necessary some time must elapse between the arrest and the presentation before the magistrate. It has been held that delay from 1.5 hours to 4 hours and failing to take a prisoner before a magistrate arrest without a warrant constitutes false imprisonment. Plaintiff states that it was over a 12-hour period of time prior to bond being set at 2:30 p.m. June 25th, 2022. The due process embraces common law maxims and principles. Deprivations of liberty, which cannot be done except by due process of law. The ancient existence of due process guarantee, and that it is prominently found not only in the Constitution but Magna Carta, which proclaims no free man shall be taken, deposed except by legal judgment of his peers or by the law of the land. The common law allowed arrest without a warrant only for known felons and breaches of peace. This is a required condition under due process of law. In order to arrest someone, thus it has been said, arrest without a warrant, where is required, is not due process of law. And the arbitrary of domestic power no man possesses under our system or of government. Muscle versus Commonwealth. But in truth, the constitutions of APA and our long-standing proceedings, presidents set those ground rules some time ago, and under them, agents cannot invoke judge-made fiction to unsettle the nation's promise to individuals that are entitled to make their argument about the law's demands on them in a fair hearing, which of one they stand on equal footing with the government before an independent judge. So I filed this motion with the court yesterday. So because they refused my whole case. So this is a motion for reconsider oral argument of manifest error of law, a due process challenge of exhaustion doctrine on probable cause for arrest, challenge of conduct as prescribed by law. So I filed this docket and hoping that the judge will actually see and hear my case and make them understand that I'm not going away. It's going to happen, but it's up to God, and that's what I put my faith in. But yeah, I just want to get on here and just say that. Appreciate everybody subscribe to me and what have you. Sorry I don't get here more often. I got a lot to deal with, all this paperwork and what have you. But y'all be safe and always record the police department. I hate to say it. We need the police department in our lives, but we don't need unjustly people. These people are they protect their own people. Which, I mean, you protect somebody, but you can't do it this way. There's no reason why I have to file all these paperwork and do all this work in regards to officers breaking the Constitution and breaking my arm. So y'all be safe out there, and God bless, and be real.